Understanding emergency custody in Claremore, when it is available, and how to request it. Understanding emergency custody can be difficult. When concerns arise involving abuse, neglect, abandonment, substance abuse, domestic violence, or other circumstances that threaten a child's safety, Oklahoma law may allow a parent or legal guardian to seek emergency custody from the court. Emergency custody is an extraordinary remedy. Courts do not grant emergency orders simply because parents disagree about parenting styles or custody arrangements. Instead, the party requesting emergency relief must generally show that immediate court intervention is necessary to protect the child from harm. What is emergency custody? Emergency custody is a temporary court order that gives one parent or guardian immediate custody of a child before a full custody hearing can be held. The purpose of emergency custody is to address situations where waiting for a normal custody hearing could place the child at risk. Because the court may act quickly, and sometimes without first hearing from the other parent, judges carefully scrutinize requests for emergency relief. Emergency orders are intended to stabilize the situation and protect the child until the court can conduct a more complete hearing. When might emergency custody be appropriate? Oklahoma courts generally reserve emergency custody for situations involving immediate concerns for a child's safety or welfare. Examples that may justify emergency intervention include allegations involving physical abuse, sexual abuse, severe neglect, exposure to dangerous drug activity, abandonment, credible threats of harm, or circumstances suggesting a parent may remove the child from the jurisdiction to avoid court involvement. The key issue is usually whether the child faces an immediate and substantial risk of harm if the court does not act quickly. Disagreements over visitation schedules, parenting decisions, or ordinary custody disputes generally do not rise to the level required for an emergency custody order. Evidence is critical. Because emergency custody requests often seek immediate court action, evidence becomes extremely important. The court may consider police reports, DHS investigations, medical records, photographs, witness statements, school records, text messages, and emails or social media communications. Judges are often reluctant to grant emergency relief based solely on speculation, assumptions, or unsupported allegations. The stronger the evidence of immediate danger, the greater the likelihood the court will seriously consider the request. Filing the emergency motion. The process typically begins with a motion or petition seeking emergency custody and explaining the facts that justify immediate intervention. The filing generally must describe the child's current circumstances, the nature of the alleged danger, why immediate action is necessary, and the specific relief being requested. The court may review the request immediately or schedule an expedited hearing depending on the circumstances. Because emergency filings require careful legal and factual support, proper preparation is often essential. What happens after emergency custody is granted? If the court grants emergency custody, the order may temporarily alter custody, visitation, or parenting arrangements until further proceedings occur. The court may also impose conditions designed to protect the child, such as supervised visitation, restrictions on contact, substance abuse evaluations, or compliance with certain court directives. The parties will typically return to court for additional hearings as the case progresses. Claremore Emergency Custody Attorneys. Emergency custody cases move quickly and often involve serious allegations that can significantly impact a parent's rights and relationship with their child. The evidence presented during the earliest stages of the case can influence how the court views the parties throughout the litigation. By understanding that emergency custody is reserved for situations involving immediate concerns for a child's safety and well-being, parents should seek experienced legal counsel as soon as possible when an emergency situation arises. For a free consultation with a custody attorney at Kania Law, Claremore Attorney's Law Office, call 918-379-4872.